Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is a time set for oral argument in our case number CR1 Dustin, is it DeRozier? DeRozier versus the State of Arizona et al. This is a time set for argument. We have allocated 20 minutes per side for argument. Appellant may reserve a portion of that time, ma'am, if you wish to do so, and if you wish to do so, please keep track of your own time on the clock at the podium. Out of respect for counsel, I would ask those in attendance to make sure your phones are turned off or on vibrate. We have read the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument. Also, our proceedings are being recorded and will be posted to YouTube, so please, when you approach the podium, tell us your name and the party that you represent. With that, let's first hear from Ms. Findley.
Good morning. May it please the court, counsel. My name is Ann Findling, law firm of Robbins and Curtin. Today I am representing plaintiff Dustin DeRozier, who appeals from a Superior Court judgment entered by Judge Gamma, granting summary judgment in a case that he had filed. On August 10th, 2009, Dustin DeRozier encountered a barrier to his participation in a program that was offered by the Department of Corrections. That program was for safer housing for inmates with certain sensitive convictions. Mr. DeRozier qualified for the program. He had a qualifying disability. He encountered a two-tier system for entry into that system, one for people who were able-minded and one for people such as Mr. DeRozier, who was disabled. And on December 2nd of 2009, he suffered the consequence of that when he was brutally attacked in a hit by fellow inmates. The issue in this case is whether Dustin presented sufficient evidence from which the jury could have concluded that he made a claim under Americans with Disabilities and the Arizona Civil Rights Act. Judge Gamma was incorrect in his granting of summary judgment, first as the state agrees to the gross negligence count, but secondly in terms of the ADA and the Arizona analogous statute. The most glaring error that Judge Gamma made in his decision was his statement in the statement of facts that Dustin DeRozier's option for safer housing was revisited after his discharge from mental health treatment. That is,
I agree with you that that was an erroneous statement. But how does that translate to error in the final decision? Because I guess this goes right to the heart of how was Mr. DeRozier denied access or participation into the special housing program?
if we go back to when he was presented with the paper regarding safer housing, at that point, what did the Department of Corrections know about him? They knew that he was too psychiatrically unstable for general population. They knew all of the facts that put him at extra risk for harm when he would be out in the yard by virtue of his conviction. But most importantly, they knew that he suffered from disabilities that could interfere with his ability to make the choice, have the entry into the program that had been developed by the state.
Counsel, when you say they knew, the person who handed him the form knew?
Well,
or how,
that's one of the places where where Judge Gamma was wrong. This is not a case where we have, like a 1983 case, where I have to show an individual knew of his disability.
Correct, I understand, but don't you have to still to point to some evidence, some specific evidence showing showing that they knew?
The most significant,
or is it about knowledge?
Well, the most significant evidence in this case is that on admission to the Department of Corrections, they being the Department of Corrections, mental health, and the mental health providers found he was not psychiatrically stable for general population.
But does that translate to are you trying to say that he was incompetent to sign that form when he signed it?
What I'm saying is that he was not in, it was not so much that he was incompetent, but that as a person with those disabilities, he required an extra accommodation. And there's no evidence that accommodation was made, an explanation of what it meant that he was signing it. We don't even know if he could read the words. And there's no evidence.
What evidence did you come from? Did you present an affidavit, an expert or some that says what his condition was and why he needed the extra assistance in order to understand the nature of the form? It seems like in your briefing that you're coming close to saying this was an absolutely involuntary decision. There's no way he was incompetent. He did not have the mental capacity. It seems like you come close to that, but you don't quite get there.
Well, what we know is what the department knew, which is that his condition was schizophrenia, which is he's having delusions. We know that he's not psychiatrically stable. He says to them, I don't feel safe. I don't know how I'm going to be safe. Now, it's not as though he would have such self-knowledge to be able to say, oh, I know that I can't make this decision, I need help. That's why it's a two-tier system. He's the person who needs the extra assistance to understand what the program is and how to gain entry into the program. This is his disability has been, there's been a stipulation that he's disabled. But if you look at what that disability is, it's that very disability. Any person with his disability would need extra information, extra process.
Let me ask you, if instead of, I think it was August, he's handed the exact same form, he's handed it in December of 2009, as he's discharged from the services he was getting and sent to the possibility of a general yard. Would your argument be the same?
The argument, well, first of all, we don't know what he would have done.
Let me ask you a better question, and
Okay.
I appreciate that, or a more complete question. And he signs a document so that it looks exactly like the document we have here today.
So he has been determined to be psychologically stable, and they revisit or initially visit the notion of where he's going to be housed. That is a different case. That's not this case. It is a different case.
And no question that's a hypothetical, but
Right.
is your legal argument, given what you've heard, it's not clear to me that your legal argument would be any different.
I think my legal argument would be that you would still look at the circumstances of he still has the disability. He still has the disability of schizophrenia, and he still has, he may have been stabilized on his medication. That may have been enough for him to be able to sign the waiver, but again, that's not what happened. In fact, that's what we think the reasonable accommodation would have been.
And I understand that, but let me ask you then, and in this
Sure.
admittedly hypothetical
Right.
world that I've handed to you, what would the accommodation look like then if it isn't? Tell us which yard you want to be placed in.
The accommodation is for the Department of Corrections, who is ever obtaining this consent, to explain in language and terms that are understandable by a person with disability, which there's no evidence that occurred in this case.
Well, but to flip that, and again, in my hypothetical world, is there evidence to indicate it didn't? And that, I think, was what Judge Brown was asking with respect to expert testimony or otherwise.
But this isn't an expert. This is not. I don't believe that this is an area that requires expert testimony for the following reason. What you're asking is, do we have to have an expert to say how a person would need to be instructed in order to comply with the statute? That's something a jury can decide. What was reasonable under the circumstances?
But let me, and to use a more lay or basic thought, in the hypothetical world of December 2009, are you effectively saying, look, the waiver doesn't matter, or the selection of which yard doesn't matter, you still had to do something more? Or are you saying this selection is not valid as a factual matter.
I'm saying this selection is not valid if, when he is released from psychiatric treatment, the department informs him of what the housing options are. I think that no matter what, the department has to show that they did something to accommodate his disability. It doesn't matter whether they did it. I mean, at some point they have to make some effort to explain to a disabled person, this is what you're choosing. You're choosing to go out in a yard where you're almost certainty of being assaulted.
So does that implicate the stability issue? I mean, does that mean that the difference between August and December is sort of inconsequential? It's more what Department of Corrections needed to do.
It's not inconsequential, because if the department has stabilized him on medication, see, the problem with the hypothetical is we don't know what the department would have found if they would have done it then, done the consent then. What we know is that his disability continued, his schizophrenia continued, but we know that he was stabilized enough, that he was felt to be stable enough to go into general population.
But if the claim is that they didn't treat him right given his disability, does the fact that, which still existed in Sam's hypothetical from December of
Right.
2009, is the stability relevant to that determination?
The stability is a relevant fact, yes, but the stability is not necessarily dispositive, but it's certainly relevant. It's relevant evidence of the circumstances. The issue again, though, is it is a two-tiered system for someone who has this disability, who he has both cognitive disability and he has mental health issues. So you're looking at someone, and did he not have capacity? I mean, we don't know because that inquiry was never done. We just know that he was determined to be disabled in a way that would require this accommodation.
How did the department discriminate then? I mean, use the word, explain to me the discriminate, because I'm not familiar
Sure.
with the ADA claims, but it does use the ADA itself
Absolutely.
talks about discrimination.
And the case law is clear that the standard for, well, let me preface it by, you're writing on a blank page in terms of the Arizona disability statute because there's not a lot of law on it. So you have certainly the ability to write on the Arizona disability law. But looking at the ADA claim, the Americans with Disability Law, the standard is deliberate indifference. It's not the same deliberate indifference that would support a 1983 in terms of an individual.
But does that mean disparate treatment, i.e., he's being treated differently than other inmates that are disabled or non-disabled? I mean, does he have to show some disparate treatment?
His disparate treatment is based on his disability. It's not that.
Where's the evidence there that shows he's treated differently?
The question is not would two intellectually disabled or people with mental illness, would they face this obstacle differently? The question is, does an able-minded person face it differently? And the answer is yes, because an able-minded person has more ability to understand and to read.
But we're just supposed to take judicial notice of that?
Judicial notice. It's a fact question. It's a fact. But it just, okay, I go back to your response to the motion for summary judgment, and I see that I don't see the things that you're drawing out here today or that you've argued on appeal. I mean, I see a short reference to deliberate indifference, but I don't see the whole notion. In fairness to Judge Gamma, I don't see that you drew out the notion that he could not make a knowing and voluntary assessment because of his mental condition. Did you make that below? But I didn't know that Judge Gamma was going to rely on the idea that that this inquiry had been done after he had been stabilized. I knew the facts going in that he was disabled at the time that this occurred. I didn't know until the minute entry came out that Judge Gamma was going to say it was all revisited that it was either revisited or came up the first time after he was stabilized. My arguments may have been different had that been the facts of the case, but that wasn't what was presented to me. That's why I think on appeal it's a little bit different issue.
Let me ask, and there's no inherent requirement to do this, but was there a motion for reconsideration or for new trial filed?
I considered a motion for reconsideration, and I didn't file one.
And I understand that, and that's how I thought the record read.
To be completely candid, my concern was I never thought that he was that the submitted entry was going to be a final judgment. And when I saw that it was a final judgment, my primary concern was I got to preserve my appellate rights. So,
and I understand that, and that it isn't a requirement that I see, but it is.
It was a consideration, and I didn't make it because I felt that. I felt that the constraint of it's a final judgment. Again,
I understand.
Much in that minute entry was not what I would have expected based on the procedural posture of the case, and having all the claims dismissed was one of those issues. I want to address just in the last few moments of this part of my argument, the state really has not presented you with case law for you to jump in and say that this is not authorized. If you look at the Bryant case, for example, that's cited, that was a case that was written before the Supreme Court weighed in and said, of course this applies to prison. So the Bryant case. Then you look at the Eurofresh case, Castle versus Eurofresh. The district court opinion was cited, but it's the Ninth Circuit opinion that says absolutely the ADA applies to the prison. So those two cases are not particularly helpful. Yet if you look at the cases that I've cited, this idea about accommodating mental illness of prisoners is not a new concept. It's not something that was freshly made in this case. The accommodations, for example, the case of the mentally ill individual who was extradited to New York, and the idea was you have to recognize that this person's disability may prevent them from telling you that you have the wrong person. Dustin's disability prevented him from being able to say, I don't understand what you're saying. The Colorado case that deals with providing medication to an inmate so that he can participate in a program that might lead to a shorter sentence or less restrictive conditions of confinement. Again, those are ADA cases, they're published opinions. They all talk about the fact that there are accommodations that need to be made in prisons for people with mental disabilities. Finally, I'm going to reserve the rest of my time, but in this case, we're not claiming that Dustin's mental illness was mistreated. What we're claiming is that he was mistreated by virtue of his mental illness. And I'll reserve the remainder of my time.
Thank you. Mr. Zulot.
Good morning, Your Honors, Counsel. My name is Scott Zerlot. I'm an attorney at Schraub, McGoldrick, Brinkman, and I represent the state of Arizona.
Counsel, for clarification, do you also represent Mr. Ryan?
I do, but he's been dismissed, and I don't believe that's been challenged on appeal.
Okay. I just, for purposes of the caption.
Sure.
Okay.
Very good, Your Honor. If it pleases the court, I'd like to jump to the Arizona Civil Rights Act, or ACRA, issue. I've briefed why I don't believe it applies in the context of prison with respect to services.
How far? Isn't there some very broad language in the ACRA that talks about, just as broad as the ADA?
Well, yes, Your Honor, but that's under the section that deals with public accommodations.
This is not a public.
No, the statute defines what public accommodations are. It doesn't include prisons, and then I cited to you the U.S. District Court decision that agreed that a prison is not a public accommodation under ACRA. That was the Bailey Newell.
So it's your position then that this we should look at the ADA and the Civil Rights Act under the same same analysis? The
Well,
same analysis applies?
if you're going to apply the Arizona Civil Rights Act, I think it's clear that it does apply under the same analysis, but I don't think it applies here for two reasons. One of which is that the prisons aren't public accommodations, and the provision of the statute that deals with public entities really just talks about physical accommodations, although it does incorporate Title II of the Americans with Disabilities Act, which in and of itself refers to services that are provided. But the way the statute is written, it's very clear that it is intended to apply only with respect to physical accommodations as opposed to other sorts of accommodations to the disabled. But more importantly,
And that sounds like a fine line. Wasn't this a physical accommodation? I mean, he's going to go live in one housing unit versus another housing unit. How's that not a physical accommodation?
well, I mean, the way I read it, they're referring more to ramps, handicap restaurant stalls or bathroom stalls, things of that nature.
But it is broadly worded.
It is broadly worded, but what is not is the remedies provision of the ACRA. Mr. DeRosier did not bring a lawsuit seeking injunctive relief. He brought a lawsuit only for money damages. The provision under the ACRA that allows a private cause of action is 41-1492.09, and that only allows a private action for purposes of bringing or seeking injunctive relief. That particular statute does not create a cause of action for money damages. The money damages provision is under the next section, which is 1492.09, which applies only to the Attorney General. That section allows the Attorney General to bring an action to enforce the ADA under the ACRA. And it allows the Attorney General to seek money damages on behalf of the aggrieved. But that's only where the Attorney General himself brings the action. And that's very clear from the statute. So the point of my argument here is just to knock out the ACRA as one of the statutes at issue in this case. They're not entitled to recover damages under that. The first comment I have with respect to the crux of this case is discrimination. And there's a difference between a situation that's handled inadequately or inappropriately and a situation that constitutes discrimination. The fundamental purpose of the ADA is to prevent discrimination or disparate treatment, using Judge Brown's question, which is found throughout the case law, the term disparate treatment, and talking about what constitutes discrimination. The fundamental purpose is to prevent discrimination against a person because he's disabled. Congress stated the public policy underlying the ADA as follows. Historically, society has tended to isolate and segregate individuals with disabilities, and despite some improvements, such forms of discrimination against individuals continue to be a serious and pervasive social problem. Hence, it's saying the purpose of the ADA is to prevent discrimination. A cause of action for discrimination under the ADA requires, in the context of a prisoner or an inmate, that a prisoner have a qualifying disability. For purpose of this appeal, we haven't disputed that Mr. DeRosier has a qualifying disability, that the prisoner was otherwise qualified to participate in a particular program or activity. We do dispute that what's at issue here qualifies as a program or activity, but let's assume for purposes of present discussion that it does. The next elements are that the prisoner was excluded from that program or activity. We dispute that he was excluded from that program or activity. But even if he was, that he was excluded because of his disability as a result of discrimination.
But to go right back to discrimination, Ms. Findling is arguing that he was discriminated against because of his disability. He was treated differently than inmates who can properly read and understand the form.
Well,
And that's the allegation.
right.
Why, how is that not discrimination? I mean, is the department just allowed to say, hey, look, we treat everybody the same? Doesn't matter. I mean, I don't know that the ADA goes that far. I mean, it doesn't say, we could say, everybody's treated the same. You need to step up and go on that sidewalk. No, if you're disabled, you're entitled to have an accommodation
Right.
made
Well-
so that you don't have to step up on the sidewalk.
Well-
So why doesn't the same type of analogy apply? If he's disabled and cannot understand the form, why doesn't he get the benefit?
Well, here's the distinction that I would draw between your example and what we're facing here. The sidewalk issue, that's an architectural accommodation that is required to be put into every building. Mr. DeRozier was not treated differently from other inmates. He was given an opportunity to participate in the program. He was allowed to choose between sex offender housing and general population.
Say that there has been somebody that obviously can't read at all, or that it was just that they're severely mentally handicapped, severely more severe. Does the department do the same thing? Just slide the paper across the desk and tell them to sign?
Well, in the latter example, the chances are that the sex offender versus general population issue probably wouldn't even be presented because they'd be in a different sort of environment.
Shouldn't there be in the statement, mental facility?
Right. In the case where someone can't read, I think that under those circumstances that helping them to understand the decision that was being made would require them to assist him to understand the words that were on the election, the form that was signed to elect general population. But again, you brought this issue up with Ms. Finley. They're the plaintiff. It's their burden to show that he wasn't given that opportunity, not the state's burden to show that he was. But
isn't that aren't these sort of factual issues? I mean, when in doubt, allow the jury to decide these.
Well, no, because I mean, the only evidence we have here is that he made that election. But this is kind of a good time for me to bring around to another key issue that's not just the discrimination issue. Again, Mr. DeRozier did not bring an action for injunctive relief. He's seeking damages. And the case law is clear that where a plaintiff is seeking damages, he has to establish that the discrimination was intentional. And there is just simply no evidence from which a reasonable jury could find intentional discrimination here.
It's not. So go ahead.
Isn't intent, I think there's a great quote, like the subject of a person's digestion, almost always a question of fact.
Well, the ADA cases incorporate the deliberate indifference standard.
Well, and that's fair, but
Right.
if all we're talking about is intent, what's in someone's mind, be it an individual's or a entity's or a political subdivision, that seems pretty facty to me.
Well, under some circumstances it can be, but in the circumstances of this case, Mr. DeRozier, like every other inmate that presents at the Alhambra intake facility, is screened by a CO3, an officer, to determine whether he is appropriate for placement in a protective segregation. And then they look and see if he has an offense or a former offense that's appropriate for this program where he can choose sex offender housing versus general population. Separate from that is where they go through the mental health and physical health screening. And the individuals that are involved in classification decisions and housing decisions, the record supports this, does not have any access to his mental and medical health records.
So the person dealing with, I'll call it the form, because that's what we have
Right.
here, the housing form, that person sees the inmate before a behavioral health assessment is done?
Well,
Is that chronologically kind of how it happens?
I think it may differ from inmate to inmate.
Fair.
In this case, he went through his mental health screening a few days before he filled out this form.
Is there wouldn't it have been better had the form been addressed with appellant in December upon release from the behavioral health services? I mean, just factually, wouldn't have that been a better thing?
Of course.
And
But that,
go ahead.
but that doesn't constitute disparate treatment from the way other prisoners are dealt with. There's no evidence that the ADC regularly gives inmates a second opportunity to make this election.
And I
But-
guess what let's talk hypothetically. If someone presents and they are manifestly unstable, speaking in a language that no one can understand, not capable of making, decisions that seem logical in any sense, are
Right.
they still given this form and said, hey, mark a box and then we'll assess you later? You see what I'm saying?
I do.
Is there a hypothetical that you would concede at some point this form it's not going to be enforceable? You got to look after stability of some level arises.
I think that some point would be where it's apparent to a reasonable correctional officer this person is incompetent to make that election. But let's go take this back to December, at the time that he's been determined to be mentally stable and is being released. There's no evidence that the mental health care providers that determined that he was stable and should be discharged from mental health unit had any input into the housing decision, or knew that he could or could not make an election to choose sex offender housing versus general population, or that he had chosen general population earlier during intake. So they don't know that what's happening.
But isn't the record, and you're closer to it in that sense than I am, but isn't the record silent on that as far as December, who knew, including perhaps appellant, whether he recalled whether he'd signed something?
Well, the record is silent on whether anyone would have known when they were making that housing classification, other than the fact that presumably the classification officer would have looked at his file and seen that he made that election,
right.
But that classification officer wouldn't have known that he was incompetent at that time, because those are medical records that are privileged.
I understand.
So that's where I get into the intentional aspect of it. I mean, at some point, there's got to be some sort of volitional decision-making to deprive an inmate of his rights under the ADA, to discriminate against him because he's disabled. And this brings us to a great quote from the Duval versus County case that I cited, where they talk about bureaucratic slippage. And they say that deliberate indifference, which is the standard for showing intentional discrimination, does not occur where a duty to act may simply have been overlooked. And at worst, that's what we're facing here. A situation where the left hand doesn't know where the right hand's doing, but that is not deliberate indifference. That's perhaps inadequacy with respect to the program.
But again, why shouldn't the jury make that call? I mean, we're asking us as a matter of law to make that call that the right hand and the left hand don't know what they're doing, but that can't, as a matter of law, rise to the level of deliberate indifference.
Well,
I mean, are there cases that would?
Well,
help
there's
us
cases.
on
There's case law, Your Honor, in the context of civil rights violations in the context of prison, where deliberate indifference is the standard, where they do, as a matter of law, find that a prison official was not deliberately indifferent. I was unable to find anything in the context of the ADA, and I've made the assumption in my briefing that the standard's the same. But in all candor, there's no case law that says that deliberate indifference standard is interpreted in the same way as in the ADA section as in the 1983 or actually it would be the 1983 section under the Eighth Amendment. But I think as a matter of law, this court can find that miscalculations or miscommunications or the left hand not knowing what the right hand is doing, or just a hole in the policy is really nothing more than bureaucratic slippage, and as a matter of law does not meet the standard for an ADA civil rights action to proceed. Thank you, Your Honor.
Thank you, counsel. Ms. Finley, rebuttal.
Thank you. I'd first like to address the deliberate indifference question that arose. The 1983 deliberate indifference cases are not analogous and are not helpful for the analysis here. 1983, the statute says an individual. The statute is very clear that says, and that's why you might have prison officials who don't talk to one another, and there may be a pass on deliberate indifference. In this case, it is enterprise knowledge. All of the knowledge of all of the medical people, all of the knowledge of the classification officers is imputed to the Department of Corrections. There's no question about that. That's very clear in the case law. It's clear from, there's many cases that talk about the fact that it's enterprise, that it's enterprise-wide or facility-wide.
In the context of a case
In
involving
context of
damages.
ADA.
Yeah, but
Yeah.
in it where a person is seeking damages.
Right, correct.
Not an injunction.
Not
Okay.
just an injunction, no, because remember what the threshold is for damages is deliberate indifference. If it was just injunction, it's strict liability. But, and that's, again, assuming that you use that standard on the ACRA, and I'm going to get back to that in a minute. But it's really important in this process that you understand what each of these people knows. They're in a single facility. The classification officer knows when she goes out to get this signed that this person is in the mental health unit. Okay, it's not as though these things happen in completely different places. There is no evidence because they didn't retain any evidence. Dustin can't tell us because he was beaten to within an inch of his life. His IQ now is drastically lower than it was before, and it didn't, frankly, start off that high. That was a direct result of his injuries. Now, the fact that the department can't come back and tell us what happened should not preclude Dustin's case. And again, you're correct, these are matters for the jury. This bureaucratic slippage idea, this is not a case of merely bureaucratic slippage. This is a case where a corrections officer knew that Dustin DeRozier was being housed in the mental health unit. And for anyone familiar with the Department of Corrections, and what the jury would eventually hear is, there's a very limited number of beds in the mental health unit. If they send somebody to the mental health unit, there is a reason why. Because that's a lot of resources. That's somebody who is very unstable. So for the department to come back and now say, well, we don't know, this person couldn't have known what this person was doing, it just is contrary. Briefly on the ACRA, the language on the ACRA allows the Attorney General to adopt rules. The Attorney General adopted those rules. Those rules incorporate Title II. This idea that, my time is up, may I finish my sentence?
You may.
The idea that it's limited to physical accommodations is not supported by either the statute, the rules, or the incorporation of Title II that was in the Attorney General's rules and in the Arizona Administrative Code.
Thank you.
Thank you very much.
Counsel, we appreciate your argument today. We appreciate your briefs. We will take the matter under advisement and we'll issue a ruling in due course. Thank you. We stand adjourned.